Good morning to those joining us out west today, and good afternoon to those of you out in the east. Thank you for joining us for today's session of our monthly legal updates for Canadian Employers series. We have a fantastic session planned for today, highlighting key recent human rights decisions across Canada. My name is Jennifer Thompson. I'm a partner in the Employment and Labour Group at our Calgary office, where I'm licensed to practice both Alberta and Nova Scotian law. I will be your moderator today, and I'm thrilled to be joined by my excellent colleagues from across Canada. Firstly, we have Alison Buchanan, who's counsel in our Toronto office, who will be speaking to some recent Ontario decisions. We also have Fatima Khan, a senior associate in our Toronto office, who will be speaking to recent federal decisions. We have Victoria Merritt, a senior associate in our Vancouver office, who will be speaking to BC cases. And last but not least, we have Jenny Wang, who is a senior associate in our Edmonton office, who will be discussing an interesting recent Alberta decision. Over to you, Jenny.
Thank you, Jennifer. So my topic is termination settlement risks. And the best way to do this would be discussing a recent 2025 Alberta human rights case. So this case is titled Marooney and Integrated Constructors Limited, and it deals with a scenario where an employer chose to terminate an employee even after they disclosed a protected ground. I'm going to go over the background facts of the case, and then we can discuss an analysis on, what worked in this particular situation. So the respondent supplied skilled labor at various remote work sites in Alberta, and the complainant was employed as a laborer by the respondent for a very short period of time at such a remote work site. Due to the remote nature of the work site, it was only accessible via private road, so the respondent provided its employees with transportation to the work site. If an employee missed the transport van, the only other way to reach the work site would be to drive themselves. Now, during that short tenure, the complainant missed the transport van 3 times. On November 2nd, 2022, the complainant advised her foreman that she had missed the transport van and would be driving herself to work. Despite being told to stay home, she still drove to the work site. Following, the complainant, later that same day, the complainant provided the respondent with a medical note for accommodation, which stated that she had a mental disability. Her mental disability caused her to miss a transport van, and as a result, she should be permitted to drive herself to the work site in such a circumstance. The following day, the respondent terminated the complainant's employment. Now, since we're reviewing the case, we know that the complainant filed a Alberta human rights complaint. She alleged that she was terminated in response to a request for accommodation. The respondent stated that it did not receive the medical note until after it had made the decision to terminate the complainant's employment, and that the complainant's mental disability was not a factor in its decision. As you may be aware, when a complainant suffers an adverse effect, it doesn't have to be, the reason doesn't have to be solely because of protected ground. It only has to be a factor. So in this case, the respondent provided some alternatives as to why they would have terminated the employee's employment. In this case, the complainant was informed of the respondent's safety rules, which included rules about driving safety and the prohibition of using personal vehicles. Further, on November 2nd and 3rd, it received 3 reports that the complainant had engaged in unsafe driving while driving her personal vehicle to work. And therefore, the complainant was terminated for breaching the respondent's policies and rules, which is completely unrelated to her mental disability. So during the complaint process, the respondent made a with prejudice settlement offer of $15,000 as general damages in exchange for a release. The respondent asserted that this offer was fair and reasonable because it was within the range of general damages awarded by the tribunal in similar cases. And while there could have been an award for lost wages, it was unlikely given the fact the complainant was terminated during her probationary period and she had a duty to mitigate. The complainant did not accept this offer, nor did she comment on whether she believed the offer to be fair and reasonable. As a result, this was moved towards the director for him to assess whether or not this matter could be dismissed on the basis that the complainant refused a fair and reasonable settlement offer pursuant to Section 21 of the Alberta Human Rights Act. So the director dismissed the complaint. Then the complainant requested to review the director's decision. In this case, when she made her request, she also alleged new grounds. So for example, that the response decision was retaliatory, as well as the respondent offended her for obtaining apprenticeships. The complainant also sought additional remedies. When the chief commissioner reviewed the director's decision, the chief noted that they had an obligation to do so on the basis of the record to decide whether the director's decision was fair and reasonable. Therefore, while the chief addressed the new allegations and the new remedies requested by the complainant, the chief ultimately determined that they weren't relevant to her assessment. So in reviewing the record, the chief can consider the merits of the case in determining what is fair and reasonable. Some of the relevant factors in making this decision or conducting the review include that, the chief can assess the respective risks of the parties. The chief can consider the fact that there is a range of fair and reasonable settlement offers. And it's also recognized that for an offer to be reasonable, it doesn't have to include all remedies the complainant is seeking or include the highest award the complainant may be awarded at the tribunal. So in this case, the chief upheld the director's decision to dismiss the complaint on the basis that there was a real risk to the complainant that the tribunal could find that the respondent terminated the complainant's employment because of her decision to drive a personal vehicle unsafely, contrary to the direction of her foreman. Further, in reviewing the case law, the chief agreed that there were several cases awarding general damages in the range of $15,000 to $30,000 arising on discrimination on the basis of disability, so where discrimination was found. In addition, while lost wages are frequently awarded where discrimination results in a loss of employment, those damages, again, nevertheless remain subject to normal contingencies. So the award for lost wages will take into account the likelihood that the complainant's employment might have been terminated even absent discrimination, as well as the complainant's obligation to mitigate any damages. Here, the complainant only worked for a very short period, was well within her probationary period, and there was the possibility that her employment would have been terminated even absent any discrimination by the respondent. So I'm sure you've been through this situation, you're talking to your counsel, and they always respond, well, if you want to terminate this employee, it depends. What is the factual scenario? So what did the employer in this decision get right in the circumstance? They were able to demonstrate that there was an alternate ground why they would have terminated the employee, completely separate from her alleged mental disability. However, I mean, I will note that the director ultimately dismissed the decision on the basis that there was a refusal to accept a fair and reasonable settlement, and not on the basis that there was no merit to the decision. So if we turn to the settlement offer, what did the employer get right? Well, the respondent offered case law, so they actually did their research. So they were able to demonstrate that settlement offers in the reasonable range. And while the respondent didn't offer any amount for lost wages, it was clear that they considered this factor. The offer was also with prejudice, so it could be relied on for a Section 21 decision by the director. Finally, what if your fact scenario is not as clear? One thing that we commonly see is that there's a reluctance to performance manage when an employee has disclosed a protected ground. So these are two separate, I guess, functions of management, right? You have your accommodation obligations, but you also are obligated to performance manage. So if the employee's accommodation is a 25-hour work week instead of a 40-hour work week, that means that during the 25 hours, they're still expected to perform their duties and responsibilities to an expectation that's that meets the role. And you can have discussions with the employee with respect to same. there's also practical considerations. Maybe there is a risk, but for operational reasons, it's better for the company to consider other options to separate this employment relationship. Sometimes you can also seek clarity with respect to whether accommodation is necessary or preferred. So, for example, sometimes an employee will make a disclosure and then provide a laundry list of what they would like to help them succeed. You are able to ask for additional information in that regard. Of course, it has to be limited just to the accommodation, but you can ask for medical support. You can also provide a supported leave of absence. So you can raise with an employee, I understand you're going through a difficult time. Would you like to use your accrued time off? Would you like to apply for go on unpaid leave and potentially use EI? And ultimately, you can also discuss with them an opportunity to package them out, right? So a settlement to amicably resolve the employment relationship. Generally, in those circumstances, however, we do recommend to have the employee raise that. So maybe the employee speaks to you and says, do you know what, I would be open to discussing a mutual separation, then this is a great option for you. I'm a little bit over time, so I'm gonna move this along and let Victoria talk about the next topic we have for today.
Thanks, Jenny. Hi, everyone. So hopping over to BC, I'm going to talk about the broad topics, workplace inclusion and liability, but I'm talking about a specific case. It's a 150-page decision out of our tribunal this year that deals with, casual topics like the Treader and hate speech. So let's jump into the facts and background because they're obviously very important here. So in 2016, so now, our Human Rights Code was revised to add express protection against discrimination based on gender, identity, and expression. It's been there a while now, but as you know, our tribunal moves slowly. So in 2017, the Ministry of Education approved resources and tools that were designed to foster an inclusive education environment, specifically inclusive of sexual orientation and gender identity. And this was called SOGI 123. There was a lot of public debate about this programming, and some of that public debate engaged in was by a school trustee named Barry Neufeld in Chilliwack, BC. So he vehemently and vocally opposed SOGI, and he spent approximately 5 years publishing criticisms of the programming online. In response to this, the Chilliwack Teachers Association filed a human rights complaint on behalf of all CTA members who identify as LGBTQ. There was some back and forth about the class, but that was in the end the complainant group was these teachers in Chilliwack who identified as part of that community. And it's important to note when we say opposed to the programming, it was not, I have concerns or I think we need more public debate. The tribunal summarizes in its opening that he broadcast the message, this was a weapon of propaganda, so SOGI, it threatens traditional family values and instructs children about the, quote, absurd theory that gender is not biologically determined but a social construct. This lie, he says, alienates children from their parents and primes them for sexual abuse. So very inflammatory and problematic content being published. And this were statements made in board meetings, at rallies, and of course, on social media, so Facebook and other places online. So the complaint alleged that this public rhetoric, which was all during his tenure as a school trustee, constituted discriminatory and hate speech, so violated Section 7 of the Code. This was partially successful, and we don't have time today to talk about the kind of hate speech piece of this and the publication piece, although it's very interesting if you are interested in that topic. And really what the tribunal does is goes through every single publication and finds whether it meets the threshold for hate speech, which is very high, right? You have to be saying quite egregious things before you're going to fall within that category. More relevantly for my practice and our group, and hopefully you, is that the second allegation was that the school trustee discriminated against these teachers in their employment. So Section 13 complaint, based on their sexual orientation and gender identity or expression. And this was successful. The other piece in this case is that, it says a school case, so there was a tension between freedom of expression, the charter, and where that crosses the line and what limitations can be imposed. The tribunal says, this can be complicated, but where it's not complicated, or relatively not complicated, is actually in employment. So I think the tribunal throughout this decision really talks about the fact that they have little patience for the idea that political discourse that's discriminatory and disrespectful is going to be appropriate in the workplace. In terms of the actual in-employment test, I think historically there's been the longstanding idea, well, you need to be the employer, or at least have a fair degree of direct control over the workplace before you're going to be potentially liable under Section 13. This case continues to reflect the post-shrink decisions that in employment is much broader than being the employer. So on this slide, if we can just go back, sorry. On this slide is a quote which kind of summarizes the conclusion the tribunal came to in this particular case, where they say that as a school trustee, a member of the board that employed the class, he was an integral part of the workplace. So that's kind of one of the first factors. Are you an integral part of the workplace? His role in the district and his public profile put him in a position to affect the teacher's working conditions, and he did. And he did by publicly denigrating this group. And the effect was a discriminatory work environment for LGBTQ teachers in the district. So, as I said, shrink was the case that says Section 13 extends to all employees who suffer discrimination with a sufficient connection to their employment context. Broader than just your employer, was there a sufficient connection to the employment context? Is the respondent integral to their workplace? Was the complainant's work performance or work environment negatively effective? And did the impugned conduct occur in the workplace? So interestingly here, obviously this conduct was for the most part not anywhere near the classroom, but the tribunal concluded that while it didn't occur directly in the workplace, the physical location is not determinative, and it's most significant that his statements ended up poisoning the teacher's actual workplace. So we can go to the next slide. Thank you. So there's a couple different takeaways from this case. The first is what I've already been talking about, which is this broad scope for discrimination in employment. And the other comment, so a lot of the defense here was kind of like, how could I possibly have impacted teachers just through my lowly position as a board trustee? And the tribunal rejected that quite stringently. And so the second piece is the test for poisoned work environment. This is a long-standing test. It's not new. The tribunal will look at what were the nature of the comments or conduct, what was the impact of those, impact being very important. But there's multiple incidents. They look at that holistically. So what, even if some of the comments were more mild, what was the cumulative effect of those comments? And the behavior doesn't need to be directed specifically at an individual. So for example, in this case, these comments were kind of sweeping comments about the community, but they were found to have a negative impact on individual teachers. So I think this decision can help embolden employers to take action when people are engaging in disrespectful commentary. I think there's a reluctance because people will raise expression, or I'm entitled to my opinion, I'm entitled to public debate. That's not untrue, but as soon as you are saying things that are poisoning the work environment for other people, there's going to be some obligations on the employer, because you're expected to maintain a discrimination-free workplace, to kind of step in there. So I think this is hopefully emboldening for employers to feel that they can manage those effectively, knowing that the tribunal has a very low tolerance. The final piece I'm going to touch on, and why I think this case got a lot of attention initially, is the damages awards at the tribunal. No surprise to anyone, they've been increasing. In the end, the tribunal awarded $750,000 injury to dignity damages for the class. I actually think this number would have been higher if the complainant had asked for it. The tribunal explains that this results in an individual awards between 5,000 to 17,000 roughly per class member. And they describe this as a reasonable, if not modest, range given the factors outlined above. And that, even though the experience between this group might have differed, recognizing that everyone has a different experience and would have been impacted differently, there was no doubt in their minds that everyone had experienced injury to dignity. The other piece of this, which I found very interesting, as many of you will know, the tribunal typically does not award costs. Here they did award costs for improper conduct, but the conduct in this case was extremely egregious. And I'm actually disappointed that they only awarded $10,000 because I think it would be nice for people to have had a higher dollar figure to remind you about what's appropriate conduct. And when I say egregious, I mean this individual was publishing information that he was told not to and was subject to a sealing order by that tribunal. He was recording and posting online settlement discussions and pre-hearing conferences, even when he was specifically told not to. He actually had a lawyer. He explained to the tribunal that he took his lawyer's advice with a, quote, grain of salt, which the tribunal obviously said he just ignored his lawyer's directions. So really egregious conduct. All right, and I am going to spend 1 minute on my last slide here, moving away from this case and just talking about a quick update on where things are at with our tribunal. Still looking very grim. Anyone involved in human rights proceedings will know we have incredible delays. So a few points. The tribunal implemented business hours for emails. So if you're emailing the tribunal, they expect you to send it between 8:30 to 4:30 p.m. Monday to Friday. They say emails sent outside of these hours will not be accepted or processed. I know they are reviewing them because I've seen responses come in. However, people are now resending emails, and I do suggest that you kind of comply with this to avoid an argument that the tribunal didn't receive it. They're also not running due diligence searches. So if you're looking for those, they've paused those indefinitely. No update about when they might recommence. Complaint processing, they're now back to complaints in February 2024. So complaints that were filed in February 2024 are being processed and hopefully served. But you can see the delay is still 2 years from filing to actually getting served with it. And their case path pilot project for applications dismissed remains in place. So you no longer have the automatic right to apply to dismiss. So I'll end there and turn things over to Allison.
Thanks, Victoria. Hi, everyone. I'm Allison Buchanan, and I'm going to talk to you guys today about 2 cases out of the Ontario Human Rights Tribunal, which, dare I say, are wins for employers, which we don't often see. So I think they're particularly noteworthy, and I'll take you through both of them today. Slide, please. We're going to start with the case of Baker and Firon Roofing, Inc. And now this situation is actually similar to something I expect we have all dealt with. And it's a situation where you have an employee who goes off on a sick leave and provides very bare bones evidence to support the same. And so in this case, there was an administrative employee working for a small family-run roofing company. And she went through a particularly stressful time and commenced a leave of absence because she said the stressful time had exacerbated her pre-existing conditions. So that's fine. She went on a leave of absence. The employer supported the same. And to support her leave of absence, she provided a doctor's note that effectively said that she is totally disabled for a period of time. And the period of time happened to be 4 weeks. And the physician said that that was his estimated time that she would not be totally disabled. So the employer receives this note and responds and says, can you please fill out this functional abilities form, which is not uncommon. And the physician said, effectively, not right now. It's inappropriate at this stage. And the employer said, okay, fine, we'll deal with that when we get closer to her return date. So as we get closer to her return date, she presents another physician's letter, which is effectively a regurgitation of the same generalized physician's letter that she initially delivered to the employer, which says, that she has been examined in his office, she remains totally disabled, and he expects she's going to be totally disabled for another period of time. Now, this is all happening around November. So don't forget, this is an employer who's a roofing company. And as we get into November, the weather starts to change, and all of a sudden there's a contraction in the amount of work that they have. So at the same time, in fact, at the day after they receive the second physician's letter extending her leave of absence, the employer makes the difficult decision to lay off this employee, in addition with some other employees, due to the contraction in business. Then we get to the spring, the following year, when she normally would be recalled, and the business has decided to eliminate her role. The employee brought an application at the HRTO alleging that the employer's decision to lay her off and then subsequently to not recall her the next season were based on her medical leave and disability and constituted a failure to accommodate. Next slide, please. Well, lo and behold, the claim failed. And the claim failed for two reasons. First, the tribunal found that the employee hadn't actually established that she had a disability within the meaning of the code, and therefore didn't meet that very first threshold she has to meet to establish discrimination. The tribunal said that despite these two doctors' notes saying that she was quote unquote totally disabled, the employee failed to prove that she had a disability. And the doctor's notes were the only evidence that she submitted on this point. But they provided, and the tribunal noted this, they provided no diagnosis, no symptoms, or information about her functional abilities. The tribunal asserted that the bare assertion of being totally disabled is insufficient. And it reiterated that not every condition constitutes a disability, and that a temporary or transient condition is not a disability under the code. And this is very helpful, I think, as an employer, because very often we get letters where there isn't a lot of detail, and the employer feels relatively paralyzed in being able to proceed and ask for further or better documentation or support, and feels limited in the way that it can properly manage its workforce. And so I want to read a couple paragraphs from the decision because I think they are particularly helpful, and I expect that we're going to be relying on them in the future because they so succinctly put the element of this piece of law into a decision that we can rely on. So the tribunal stated, and bear with me as I read this, that an applicant cannot establish that they have a disability under the code just by asserting they have one. There must be sufficient, reliable, and relevant evidence to prove that they had a medical condition and that their specific medical condition can meet the statutory definition of disability. Even if the applicant can identify a health concern or a medical condition, not every condition constitutes a disability within the meaning of the code. For example, the tribunal has repeatedly held that everyday illness or a temporary or transitory condition is not a disability, as that term is defined by the code. And the mere mention of being quote unquote totally disabled is insufficient to establish an existing disability. There is no diagnosis or articulation of the symptoms suffered by the applicant in the physician's letters or in the applicant's oral testimony. So I really like those paragraphs because I think it does so succinctly put the decision on the record, and it gives us something that we can rely on in the future when we're dealing with a situation like this, and I expect that we will be doing so. But wait, there's more, because the tribunal didn't stop there. Tribunal went on and said that even if she had that disability, the employer had a valid non-discriminatory reason for the layoff and then the role elimination. And the way that the employer did this, and this is a similar thing to what Jenny was talking about, was the value of the evidence that they provided. So the employer provided really good evidence that there was a contraction in the market. They provided weather charts. They provided financial statements. They provided records of employment of the other employees who were laid off in and around that same time that showed that this wasn't something that was directed towards this employee. And then they showed evidence that the role had in fact been eliminated. And so while the tribunal accepted that the employee had suffered an adverse impact, it found no evidence that the disability was a factor. Now, I'd like to say this is a win. I do think this is a win. I really like this decision. But I will say one caveat about that. And that is when you read the case, one of the major issues the tribunal had was with the evidence the applicant presented. So the applicant was self-represented, and all she gave the tribunal were the two physicians' letters that were effectively exactly the same and said she was quote unquote totally disabled without anything else. And the tribunal had a really hard time with that. And it indicated in its decision that had there been more, had she provided more evidence, had she been able through her oral testimony at the hearing or through any documentary evidence or through even calling the physician as a witness at the hearing, had she been able to provide something more to help the tribunal understand that this wasn't just a transitory illness, that this in fact was a disability, the decision indicates there would have been more of a willingness to apply this broad interpretation of disability that the code enshrines. And so I do think that this case is a little bit unique because of the lack of evidence that the applicant provided. I'm not sure we'd always have that same situation. And it certainly, the tribunal's decision certainly indicates that they would have been more sympathetic to finding, I think, a disability as defined under the code had she presented better evidence. So, well, I think this is a win, and it's a really great decision, and I expect we are going to be relying on it in the future. I would be careful relying on it to the strict degree, because where there are different evidentiary factors or where there's more evidence to support the individual's disability as it's defined under the code, we could have a different outcome. Next slide, please. All right, moving right along, we're going to be moving right along in the employer win department. We'll be talking about the case of Gautier and Ignace Township. And this has to do with retirement planning in a sense. Effectively, this deals with a situation where an employee's long-term disability, LTD benefits, were discontinued when he turned 65. Now, many of you know that mandatory retirement ended in Ontario in 2006. And many people believe that as a result, there can be no employment decisions based on age alone. However, in some circumstances, like the one we're about to talk about, where employment decisions can be made, discontinuing a benefit based on an employee's age alone does not actually breach the code. So in this case, we had a full-time employee who was working, and then he commenced a leave of absence. And while he was on his leave of absence, he became eligible for long-term disability benefits and started receiving the same. Shortly before his 65th birthday, he was informed that his disability benefits would end when he turned 65. And the employer also told them that the $900 a month supplement that they had been providing him during that period would also be discontinued. The employee brought an application at the HRTO alleging that the termination of his LTD benefits at age 65 constituted age-based discrimination. Next slide, please. In response, the employer said the tribunal had no jurisdiction over this. So the application should be dismissed in accordance with section 25, subsection 2.1 of the code, which creates an exemption to the prohibition on age-based discrimination. Now we're going to get a bit technical here, but I think it's valuable. So I hope I explain it well and we can all follow along. The provision in section 25, sub 2.1 states that the right to equal treatment based on age in employment is not infringed by an employee benefit, pension, superannuation, or group insurance plan or fund that complies with the Employment Standards Act and its regulations. Okay, so then we look at the Employment Standards Act and its regulations, and we see that it prohibits discrimination with respect to group benefit plans based on age, but defines age as any age of 18 years or more, or less than 65 years. So as a result, individuals younger than 18 and older than 65 are not afforded the same right to equal treatment in employment with respect to a benefit plan that terminates due to age. So because the LTD plan in question complied with this ESA scheme, the tribunal found it had no jurisdiction to consider the application. The tribunal found that the termination of benefits at age 65 in the employer's LTD plan was compliant with the ESA and therefore also the code. And like I said, it found that it had no jurisdiction to consider it. A helpful quote I liked that I pulled out from this decision reiterates a really well-referenced principle that the tribunal cannot consider general allegations of unfairness related to the code. And so the application was dismissed on a preliminary basis. Next slide, please. But there's always a but. Now this decision, again, I think it's a win for employers, but it's not quite the slam dunk that we're hoping for or that it appears to be. And that's because the applicant in his application had asserted the intention to challenge the constitutionality of this section 25 subsection 2.1 exemption for breach of section 15 sub 1 of the Canadian Charter of Rights and Freedoms. And section 15 sub 1 of the charter says that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. However, the applicant didn't go any further. That was it. That was the entire reference to the intention to bring a constitutional question forward. He made no constitutional arguments and he didn't file the required notice of constitutional question. However, in his initial application where he showed this intention, where he included this intention, he referenced the seminal decision of Talos and Grand Erie District School Board. And so in its written decisions in this matter, the tribunal addressed it. And in doing so, the tribunal distinguished from Talos, where the applicant's loss of extended health and dental benefits due to their age was found to be unconstitutional. And here the tribunal said, this case is different, and it's different because Talos didn't address LTD, pension, or superannuation plans. It is not binding. And it has not been followed in subsequent decisions of human rights tribunals when considering disability benefits plans. So while the decision is overall positive and I think helpful and reiterates a lot of what we already know, but reiterates it in a modern way, it should be noted that the tribunal has yet to directly determine the constitutionality of section 25 sub 2.1 as it applies to age limits in an LTD plan in a case where full constitutional arguments have been made. So there's this foreshadowing of potential challenges to come. But currently, it's good law, it's a good decision, and I think we can take it as a win. So that's it for me. Thanks for listening. And I'll pass it now on to my colleague Fatima to talk about harassment and employer liability.
Thanks so much, Allison. So for our federally regulated attendees, we have an update on the number of active matters and hearings that are being scheduled at the Canadian Human Rights Tribunal, which I think can sometimes be helpful in just understanding how matters are progressing through that tribunal's process. And then we can get into a recent decision by the same tribunal concerning discriminatory harassment in the workplace. So last year, the Canadian Human Rights Tribunal received approximately 112 new applications that had been referred from the Commission, and a total of 41 different matters or applications were scheduled for hearing dates. And that includes hearings on the merits of the applications, so like the actual substantive issues that have been identified, as well as any preliminary or procedural issues, so things like delay, production, and the like. Although we don't have the specific numbers for a bunch of these metrics that you see on the screen for 2025 yet, it does appear that the Canadian Human Rights Rights Tribunal is making its way through its inventory of applications over the last few years. So for example, you'll see that in 2021, there were about 405 total new active applications at the tribunal, but by 2024, that had kind of come down by about 150 to approximately 249. And of course, that includes having to take into account all the new applications that have been coming in over the course of those couple of years. Another thing to note is that the Canadian Human Rights Tribunal appears to be increasingly scheduling more matters to hearings and growing the total number of hearing dates at the same time. So back in 2021, you'll see there were about 17 matters going to hearing across 155 hearing dates. However, in 2024, that increased to 38 hearing dates. 38 matters going to hearing dates across 190 hearing dates in total. So for 2025, the only statistic that the tribunal has provided so far is that 41 matters have been referred to hearing dates, but we don't really know how many total hearing dates that has constituted. But I imagine it would possibly be on the upward trajectory, just looking at what we know from recent years. I think the more relevant topic might be, how long is it taking these matters to actually go to a hearing once an application has been filed? And of course, I'm sure as many of you know, some certain complaints are much more complicated than others, just based on the issues that have been raised, how complex the facts are, how many witnesses need to be brought in, and all the evidence and arguments that need to be raised. So such cases could take many, many years. But it seems that based on what the tribunal has stated, for complaints where the first day of hearing began in 2025, the longest that application had sat at the tribunal, and perhaps the more appropriate term is languishing at the tribunal, was almost 13 years. Whereas the shortest period that an application had been with the tribunal before its first day of hearing in 2025 was less than a year. So there may not be any rhyme or reason to which matters are going to a hearing, but it does seem that it can still take many years for a hearing to be scheduled at the tribunal. But overall, it appears that the Canadian Human Rights Tribunal is moving a bit faster in trying to process its matters. And one of those matters is the recent decision of Singh and First Call Trucking Limited, which we'll be discussing today. So this is an application by an employee concerning allegations of discriminatory harassment in the workplace. Very briefly, the applicant employee was a truck driver for an employer respondent that was based in Alberta, though its trucking operations were crossing into other provinces. The applicant had sustained an injury to his hand as he was performing work duties while he was operating his employer's truck, and the accident actually occurred in Quebec. So he underwent surgery, but continued to have restrictions related to what he was able to do with his hand following the surgery. The applicant alleged that he experienced discriminatory harassment by both the owner of the respondent company as well as his manager after his injury. The employer didn't defend this application, so the only evidence that the tribunal heard came from the applicant himself as well as his wife. And just generally speaking, the allegations of discriminatory harassment based on the applicant's disability included things like comments from his manager that his injury was not that bad and he was therefore making excuses to not return to work in his full duties, but rather seeking or requesting modified duties. The applicant alleged that the employer asked to contact the workers' compensation board that had to be brought in because, he was injured as part of carrying out his work duties, and basically tell them, hey, go tell the workers' compensation board that you don't actually need modified duties. The employer alleged that the applicant alleged that the employer wanted to fire him, but that the only reason they didn't do it is because they realized they would owe the workers' compensation board money. So that was the only reason they had kept him around. Other allegations included his manager swearing at him when he refused certain modified duties over others, claiming that his refusal on the basis that the proposed modified duties were inappropriate or medically unsafe were not true. And the one allegation I wanted to really note for you was they allegedly told the Workers' Compensation Board that he was illiterate. And around the workplace, they would refer to the applicant as the Workers' Compensation Board guy or the WCB guy. And so that kind of framed what this complaint was about. So the test for discriminatory harassment is framed a bit different under the Canadian Human Rights Act, but the main considerations are essentially the same and what you would see in any jurisdiction. And as you know, the actual complaint really has to do with the specific facts and context, and that's usually what's driving the analysis, regardless of what test or factors you're looking into. So the tribunal had to determine whether the conduct itself constituted harassment, whether the harassment was tied to a prohibited ground under the CHRA, and did the discriminatory harassment occur in the context of the applicant's employment. So of course, under the first part, as you'll know, the conduct needs to be unwelcome and unsolicited, and it needs to constitute something arising to hostility, intimidating behavior, or offensive behavior to the victim, or something that demeans or humiliates them in the workplace. And something the tribunal noted in this case was whether offensive conduct is connected to a prohibited ground is determined using the reasonable person standard. So, in other words, would an objective person acting reasonably look at everything that's alleged and assuming it's true, or if having it been true, would they consider the conduct harassing? And another thing the tribunal noted, which I think is interesting, is whether the behavior that's alleged to be unwelcome, it's evaluated in real time to the applicant's response to that conduct. However, a verbal no is not required to establish that the behavior is unwelcome. And moving on to the next part of the test, I don't think it's that complicated. It was tied to the applicant's disability, related to his injuries to his hand and him seeking modified duties by way of accommodation when he came back to work. And again, often the nexus between the conduct and the employment is usually self-evident, as it was in this case, because it arose at work while he was again trying to seek that accommodation. So moving on, the tribunal found that the applicant and his wife were credible witnesses. So unsurprisingly, based on all the allegations I just read out, the tribunal found that the applicant was subject to harassment by the respondent employer, and the employer was ordered to pay about $30,000 in damages as a result. So as employers, just a few things to keep in mind. First being that even an informal comment or nickname that kind of takes place or uttered by a manager, and it's really not dealt with appropriately in the workplace, can be sufficient to ground a harassment finding at the CHRT. The second thing to know is where the harassing individuals are members of the company's leadership. So in this case, it was the owner of the company as well as the individual's direct manager. In those sorts of circumstances, it's very difficult for the employer to be able to kind of rely on a defense where they say, like, we didn't know about the allegations, or we didn't consent to it, or we were able to manage the allegations as they came up, just because when it's the highest level of members of management doing it and there's no real avenue to kind of pursue a claim or file a complaint or get a harassment investigation going, then you're kind of out of luck, and it's really hard for a company or a corporate entity to kind of rely on that. And lastly, when you decide not to participate in defending a human rights application against you as a company, that doesn't mean that the application is going away, and it can actually make an adverse finding against you far more likely by an adjudicative body. So it's always good to reach out to your counsel and get a response in place. I'm now going to turn it back to Jennifer, who may be able to look at some of the Q&A and see if there's any things we can expand on.
Well, thank you everybody for those valuable insights. We're going to move on to the question and answer portion now of our session. So if anybody wants to to submit any questions, that would be great. Just turning back to Jenny's slide about the Alberta case, I think from my perspective as an Alberta lawyer, I just find that case really useful as a reminder of that power that the director has under Section 21. I think it's an often overlooked area of a strategy to get rid of claims, in my view. The best bit about it, I think, is that if they do reject it and the director finds that it was unreasonable to reject it, then the employer doesn't even have to pay them the money. They just lose their case and they don't get anything at all, which is quite a nice little ending to it. And I know from my own practice, I'm using it increasingly as a strategy with clients at conciliations, to make the last offer a with prejudice offer, and then to put that through with the submissions to the director. And we are having some success with that. So that's been really helpful. And just a question for you, Jenny. When obviously in that case, the employer had made the decision to terminate already, and then the employee disclosed the disability and provided the medical note. When an employee discloses a medical condition or disability close to a termination, what would you recommend employers do to assess the timing and document the decision to try to mitigate that risk of a claim like this?
For sure, Jennifer. Thanks for the question. So obviously it depends in this case because the decision made to terminate did already occur prior to receiving the medical information. The fact that the employer decided to proceed with the termination without really any delay upon receiving the medical note, that was reasonable in the circumstances. However, if you don't have that kind of clear evidence or documentation, then it may be necessary after receiving the medical note to actually assess, okay, have any of our concerns with the employee been associated with whatever disability that they disclosed. So for example, an employee might disclose a mental disability and say, I've had difficulty completing certain tasks because this is the kind of accommodation I need. Now, if we don't have sufficient documentation prior to disclosure to kind of have alternate basis for termination, and now we've received this disclosure, then the employer should take steps to document, okay, we've received this. What are we doing to accommodate the employee? How are we working with the employee? And again, it's going to be, that dual role of managing your accommodation obligation as well as performance expectations. So the employer requests this, it's medically supported, we provided this, but the employee is still not meeting expectations with respect to their duties and obligations, then we can discuss further on next steps. But generally, and I know, for example, in this case, we are talking about mental disability, but for example, if an employee goes on a protected leave, such as, they become pregnant, so they go on a maternal or parental leave, and then they come back, even if there was, for example, some documentation prior to them going on that leave, the bigger the gap there is between them returning from leave and the termination would generally help mitigate against risk.
Yeah, no, that's
your question. Thanks, Jennifer.
Yeah, no, that I agree. I think it's always a tricky one, and it happens quite frequently. I find when people feel like they're at risk of being terminated, that they suddenly appear with a note or go on a leave of absence to try to reduce the chance of being terminated. And I know in my own practice, I advise that people, take extreme caution, especially where there's any suggestion that the disability that's being disclosed might be linked to the underlying performance reasons that you're terminating for, because that is going to increase the risk. In that particular case, it sounds like the reason for the termination was safety related, so wasn't linked to the disability at all. But I think it would be very different if you had a situation where the employee, for example, was being terminated for performance reasons, and there was a risk that those performance reasons were connected to that disability that had just been terminated. So for sure, if you have that kind of situation, we recommend that you reach out to your usual advisor. So another question, I found Victoria's summary very interesting. This is a really tricky situation for employers. So I apologize for the question, Victoria, because it is a tricky one. But what do you recommend organizations do to prevent a poisoned work environment where public or off-duty conduct starts to affect other employees, but the conduct, they don't actually say anything within the workplace? What do employers do then?
It's a very, very good question and tough. So I think one thing is having a social media policy and some expectations around how employees are actually using social media, and clarifying at the outset and through your policies that yes, what you say on your own time, if it has a connection or impacts people negatively at the workplace, even if that's on social media, that may flow, there may be consequences that flow from that action. In terms of, where is the line? Because people are obviously entitled to have different opinions on contentious topics. We're in very polarized times. So I think, as soon as you have something that ties back to the workplace or is experienced in a way that make people feel unsafe or discriminated against at work, there's an obligation as an employer to address that. And I think it's important to remember that while the employer is responsible for, trying to create and maintain a discrimination-free workplace, you can't control what people do directly. So part of it is being prepared to manage that behavior when it comes to your attention, when somebody reports it, by actually investigating and addressing it. And it's interesting, I was trying to think of examples, because this comes up a lot. Something like a show like Bridgerton. This would be a very niche example. I'm sorry if nobody watches that or has heard of it. Bridgerton was based on books, and there was a lot of backlash online because people were upset that they swapped some of the storylines so that you now have characters that were dating a man, and now the romance interest is a woman. So if somebody posts about that and says, I'm frustrated, you know, that's not really necessarily reasonable for somebody to come to you as an employer and say, oh my gosh, they posted this view on their private Facebook posts. That's very different than somebody saying something like, oh, my employer finally caved to all the liberal pressure and put in gender neutral bathrooms, right? This is now, you are now connecting that and potentially really making people feel unsafe and uncomfortable in the work environment. So I think they're not easy situations. I would recommend erring on the side of caution. And as soon as somebody raises concerns, you do need to look into those. It might be that it's not conduct that is going to cause a poison work environment or reach that threshold, because again, people are entitled. And even in this Neufeld case where, the comments were quite inflammatory, the tribunal was careful to say, you can engage in discourse on these issues, right? Like you can hold some of these views, but it has to be done respectfully and it can't be done in a way that is adversely impacting people in the workplace. But yeah, I think going back to my first response, now more than ever, it's important to have social media policies, because then you have something to point to in black and white saying, here's our expectations of you when you're using things online that other people can access, and also being wary of people connecting back to the workplace. So you are not the employer who goes viral with people sending you messages because one of your employees has done something that a number of people find extremely offensive. So yeah, I think be prepared to address those issues because they're coming up more and more often, unfortunately.
Awesome. Thank you very much, Victoria. So that brings us to an end today. So just to conclude, thank you again to all our panelists for sharing their expertise and for all of you for joining today's session. We hope that it's provided practical insights into key employment law developments.